So in this video, we're going to be talking about a unanimous Supreme Court decision, which involves the warrantless search and seizure of firearms. And we're going to talk about how this concept impacts you. Now, really quick, before we jump into this video, I want to ask you all for a huge favor. If you're not currently subscribed to the channel, please consider subscribing to the channel. About 60% of all my viewers are not actually subscribed. And so one of the ways that you can support this content for free is subscribing and then also just sharing it around. And all that really does help this channel to grow and to reach more people. As I mentioned in the intro, in this video, we're going to be discussing Supreme Court cases, one of which was a unanimous decision involving the warrantless search and seizure of firearms within the home. The cases we're going to be talking about and breaking down and covering the concepts around is the Caniglia v. Strom case and then also Torcivia versus Suffolk County. Torcivia involved the use of the special needs exemption to the warrant requirement to confiscate firearms based on a single call that a grandfather was acting irrational. The Torcivia case is similar in nature to a different Supreme Court case we've covered, and it was a Supreme Court unanimous decision in a case called Caniglia versus Strom. In Caniglia, the Supreme Court issued a unanimous ruling on whether the community caretaking exception that applied to vehicles could also extend to the warrantless search and seizure of homes and ultimately result in the seizure of firearms. These two cases are critical for all gun owners like you to know, especially with the increase of red flag laws and their current enforcement. And it also is kind of this gray area where the Supreme Court has been kind of wishy-washy on, and some states are being aggressive in these areas. Now, the facts surrounding the Torcivia case are very interesting. Wayne Torcivia is a 57-year-old man with no record of violence, no history of suicide attempts, depression, mental health issues, or anything like that. Early in the morning of April 6, 2014, his teenage granddaughter called social services, complaining that her grandfather was yelling at her and acting weird. Following that call from his granddaughter, social services contacted the Suffolk County Police Department, which ultimately sent 3 officers to his home. When the police officers arrived at his home, they all agreed that they, had no issue with what was going on, no crimes had been committed, and really that the granddaughter's complaint was completely false. However, at one point during the discussion between Mr. Torcivia and one of the officer decided, to turn slightly or just turn slightly, and then accidentally knocked down a magnetic drape that was attached to his front door. As Mr. Torcivia went to pick up that drape that fell, the officer then screamed at him very loudly to essentially say, "Get back," and he threatened that he would tase Mr. Torcivia if he didn't get back. Mr. Torcivia claims that in response to the police officer being a little bit more aggressive and threatening to tase him, he said essentially he had a heart condition and he could die. So his response to him was saying, "Hey, don't tase me, I have a heart condition and I could die." But the police officer alleges that what he heard Mr. Torcivia say was that Mr. Torcivia claimed he wanted to be tased and wanted to die. And it's because of this misinterpretation or these statements that the police officer hearing that thought, he made statements about wanting to die or maybe there was some sort of issue. And so they handcuffed Mr. Torcivia and then transported him to a psychiatric hospital for an emergency mental health evaluation. And really from here is where everything spirals out of control. After dropping him off at the psych evaluation, one of the officers learned from a computer check that he had a New York State pistol license, and therefore he also probably had firearms within his home. At that point, the police officer then contacted his sergeant, and the sergeant then instructed that police officer to get in contact with Mrs. Torcivia and ask about those guns and try to get possession of those firearms. However, both Mr. and Mrs. Torcivia denied the police officer's consent to seize those firearms. Eventually, his psych evaluation came back clear, of course, because nothing was wrong, and 12 hours later, he was recommended to be discharged from the hospital. However, a social worker on the case then told an intern to get the combination to the gun safe and get in possession of those firearms. The intern then called the wife and said, there were plans for the husband to be discharged, but he would only be discharged if he gave up possession of those firearms. The social worker intern then also called Mr. Torcivia at the hospital and told him he would not be released until the firearms were confiscated and that the police were on their way to his home to get the weapons and they needed to give up the combination to the safe. Eventually, Mr. Torcivia did decide to give to the pressure because he was going to be stuck in the hospital for psych evaluations with no potential being released. So he gave the combination and ultimately the firearms were given to the police department. Now on May 6, 2014, he then requested the return of his firearms from the police. His pistol license was then also later revoked because of this incident, and really it ended up taking about 2 years for the department to release the long guns to him. They had to go through a gun store for them to be released, and they were transferred back to him, but then I believe also some of the handguns were never given back to him. So those are some of the basic facts surrounding this case, and this issue essentially spiraled out of control from a baseless call from a teenage granddaughter who maybe had issues with the grandfather, was upset about something. You never know with this generation, but they were upset about the grandfather doing something, called the police on him, and then all this spiraled out of control to him being put in a mental health facility and then threatened to never be released unless he gave up his firearms, which he had to do. And also keep in mind, this all was done without a warrant, and he still has not received his handguns back. This was a warrantless search and seizure of those firearms. This case eventually made its way up to the Second Circuit for review, and on review, the Second Circuit found that under the special needs exception to the warrant requirement, the police were able to engage in this type of conduct. In reaching that ruling, the Second Circuit largely ignored the Supreme Court's unanimous decision in the Coniglia v. Strom case, which we're going to cover here in just a second. The Second Circuit Court of Appeals simply asserted in that footnote that the special needs exception that was used in this case, Torcivia, is different in essentially in some ways than the community caretaking exception that was at issue in the Coniglia case. Now, for those not aware, the Supreme Court has issued a unanimous ruling in a case called Coniglia v. Strom. That case dealt with whether the community caretaking exception that applied to vehicles could then be extended to the warrantless search and seizure of firearms within a home. In 1973, the Supreme Court decided a case called Katie v. Dombrowski. In that case, the Supreme Court held that police officers had not violated the Fourth Amendment by searching without a warrant the trunk of a car that was towed after an accident. However, in the Coniglia case, the First Circuit Court of Appeals held that the community caretaking exception to that whole warrant requirement could also apply beyond vehicles and could apply to homes and searches within homes as well. Therefore, they found that the police officers could enter the home and seize Mr. Coniglia's firearms without a warrant under the community caretaking exception. Eventually, the Coniglia case made its way up the Supreme Court, and the court issued a unanimous decision in favor of Mr. Coniglia. Justice Thomas, writing for the majority, stated in that opinion that the Fourth Amendment protects the right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures. The very core of this guarantee is the right of a man to retreat into his own home and there be free from unreasonable governmental intrusions. Now, based on that, the Supreme Court issued a unanimous decision and unanimously found that the warrantless entry into the home of Mr. Coniglia to seize his firearms was in fact unconstitutional. In the Torcivia case, the petitioners were seeking a summary reversal by the Supreme Court because the Second Circuit outright refused to meaningfully apply Coniglia. Because of that direct violation of the Supreme Court's precedent, they requested that the court issue a summary reversal, which is kind of a harsh remedy available to the Supreme Court that they often don't use when it comes to lower courts or lower court defiance, but it is one of those mechanisms that the Supreme Court has. Now, in the opposition, the government argued that the Supreme Court should not review that case at all because they claimed there were technical errors in some of the pleadings and some of the arguments. The government argued that there were some claims about the improper entry into Mr. Torcivia's home, but those were only in relation to the original Second Amendment claims that were brought. But eventually those Second Amendment claims were dropped. So they say you can't also say that that is still at play, not only the Second Amendment claims, but also the warrantless entry into your home, because that was only tied to that one claim that you then dropped. So the argument by the government was that the special needs exception and the community caretaking exception are too far apart for essentially Coniglia to also apply in the Torcivia case. Therefore, they argue the Supreme Court should not review that case at all. And ultimately, the Supreme Court agreed with the government, and the government not only won the summary reversal that was denied, but also the case was not granted review. Now, in contrast, in the Coniglia case, after the Supreme Court issued that unanimous order striking down the whole community caretaking exception, the parties did end up entering into a settlement agreement, and there was undisclosed terms. So that was positive, but now there's kind of this gray area where you have the Coniglia case, and then you have the Supreme Court's denial in Torcivia, failing to apply Coniglia. So there's a lot of question marks about, what happens with the warrantless search and seizure, under these exceptions to the warrant requirement, and how does that interplay with the search and seizure of firearms, especially as the government continues to push for red flag laws more, and these types of, community caretaking or special needs are applied more, and specifically also when it comes to red flag laws. But unfortunately, the Supreme Court has been a little bit all over the place on this issue. That unanimous decision by Coniglia was a positive development, but then there was a whole issue that stalled out with the denial in Torcivia. And so now there's kind of these weird exceptions that are out there, and the special needs exception was expanded despite what happened in Coniglia. So hopefully you guys got some value out of this video. If you guys have any questions, go ahead and comment down below, and I will try to answer the best of my ability. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.